I'm Mitch Ackal, and this is my partner, Jeremy Walter. We are commercial and business litigators here at Gray Reed, and we're really excited today to be talking about the new Texas business courts. First things first, at the very end of the presentation, there will be a QR code that flashes up on your screen so that you can claim your CLE credit. So hang in till the end so that you can get the credit. And then also there should be a Q&A box on your screens. Throughout the presentation, please ask questions, and we'll reserve some time at the end of the presentation to come back and answer them. And so again, we're really excited about the new Texas business courts and the forum that it gives businesses to handle and adjudicate their disputes. Today, what we'll do really generally is just give you the basics of the court. We'll talk about who the judges and justices of the new 15th Court of Appeals are. We'll talk about the jurisdiction of the court, some removal and remand procedures, and then some recently filed cases. One thing you'll hear today is that this court is instructed under certain circumstances to draft and file written opinions explaining their reasoning for their rulings. And the courts have already issued several rulings and opinions that give us an idea of what the statute means. And in that respect, please know that when you see the language of the statute, or when you see the language on these slides, it's verbatim from the statute. And we're still in an early stage of the process here where we really don't know what a lot of this stuff means. So generally speaking, what is the Texas Business Court? Well, this is a statutory court that was created by the Texas legislature that became effective as of September 1st of last year. So we're about 5 months into it. You can find the law with respect to the court and its jurisdiction under Chapter 25A of the Texas Government Code. And then the Texas Supreme Court also promulgated several new rules of civil procedure, which are now found in the Texas Rules of Civil Procedure 352 through 360. This court is a court of limited subject matter jurisdiction, unlike our district courts, which have general jurisdiction. And it's really one court with 11 divisions, not 11 different courts. And then all appeals from the court and all of its divisions will go straight to the 15th Court of Appeals, which is a new Court of Appeals that has been established in Austin. And so with that, Jeremy, why don't you kind of give us an idea of where the courts are located and what they do?
Yeah, absolutely. So like Mitch said, the court was created last year, effective September 1st. And while there are 11 divisions, there are currently only 5 open and operating divisions. You see them here on the slides, the 1st, 3rd, 4th, 8th, and 11th. And as you can probably see from the map, those track and correlate to the major urban cities and areas with Dallas, Fort Worth, Houston, Austin, and San Antonio. The other 6 divisions are supposed to become effective September 1st of next year, 2026. The 2nd, 5th, 6th, 7th, 9th, and 10th. And those track the administrative judicial regions that were already in existence prior to this legislation. Now, we've called out Montgomery County there. That's an example we're going to use a couple of times throughout the day today, just because it borders Harris County, where we're located here in Houston, because it's easy to kind of forget or get sidetracked, confused, because there's no operating division currently in Montgomery County. And so when we're talking about the business courts, if you go across county lines, where you're in Harris County, we have a business court. You go up north, travel up 45 Highway, you go a little bit too far, there's no operating division. And if you're in a county with no operating division, you no longer have the opportunity to remove a case to the Texas Business Court, nor to file a case in the Texas Business Court if your only proper venue is a county like Montgomery County, where there's no operating division. And we'll talk about that a little bit throughout the presentation today and use that example. So again, we're expecting to have all 11 operating divisions by September 1st of 2026, but only if the legislature appropriates the funds to open those other divisions. Now, we do expect that to happen. The feedback we've heard so far from the representatives we've talked to is that that is the expectation. And in fact, we've spoken with some legislators who expect that there's going to be revisions as soon as this next session to some of the feedback they've already received about the business courts, make some changes, make some improvements, things like increasing the compensation for the business court judges, try to keep the courts operating effectively and smoothly based on what they've already heard from practitioners. So we're excited to see what those changes might be. Now, as far as those judges go, the governor appoints the trial court, business court judges. There's already 2 judges in place for each of the 5 operating divisions. And for the other 6, there's going to be 1 judge in each of those divisions, but they will not be appointed until at least July 1st of 2026, with the expectation, again, that those divisions begin September 1st of 2026. And then for the 15th, Court of Appeals, the new Court of Appeals, there are 3 justices that have already been appointed by Governor Abbott, and I'm going to introduce you to who those are in a moment here. The 15th Court of Appeals has exclusive jurisdiction over appeals from the business court and exclusive jurisdiction over original proceedings for business court actions, such as mandamus proceedings for those judges, for example. Now, the 15th Court of Appeals does have other jurisdiction. For example, there's constitutional orders for certain state agencies that the 15th Court of Appeals is supposed to be able to hear. There's also a bit of an open question, kind of an interesting nuance we ran across recently, given the way that the appellate court jurisdiction works, that the 15th Court of Appeals, as you see on the screen here, it's composed of all counties in the state. And it was the legislation that created the 15th Court was drafted that way because the business court is going to operate in all counties of the state. Well, the way appellate court jurisdiction works is that you appeal from the trial court into whatever appellate court has jurisdiction over that county. And since the 15th Court of Appeals technically operates in all counties, some savvy practitioners have already started trying to appeal to the 15th Court of Appeals in all types of cases, claiming that the 15th Court technically has jurisdiction in all counties of the state. Now, we don't think that that's what the legislature intended, but that's what the plain language of the statutes currently say. So we're probably going to see some interesting cases come out of the 15th Court very soon here on what the limits of their jurisdiction are. But that's a topic for another day and probably a whole other CLE. So anyway, the 15th Court is located in Austin, even though it's going to be doing business all throughout the state in any county. It will eventually have 5 justices appointed by the governor, who will ultimately be elected statewide after they serve their initial terms. But again, there's currently only 3, a chief justice with 2 additional justices. And after September 1st of 2027, we're going to be adding those additional 2 justices for a total of 5. So who are the judges and justices? Actually, before I get to that, I do want to point out 2 quick updates. For the business court and the 15th Court of Appeals, just logistically, the business courts have decided that currently they're using a website called Research Texas. It's Search Texas as kind of their portal for their clerk, for their opinions and court documents, instead of having a separate like county court document depository. And court documents filings are currently free on Research Texas. So instead of going to the Harris County District Clerk, the Dallas County District Clerk, Research Texas is the depository for filings. And then the Texas Business Court, it has a txcourts.gov website for its opinions. You can just Google Texas Business Court opinions, and they're currently posting their opinions on a txcourts.gov site where you can access those. So that's just a logistical issue. So the current judges and justices, in some of these presentations, we've been giving background on each of these judges. I want to be cognizant to leave time for Q&A, so I'm not going to do a deep dive today. But many of you probably recognize some of the folks on the screen. Really, they come from diverse backgrounds, but we have former trial court judges, former appellate court justices, really all very, very qualified. And there's a reason for that, because the legislature wisely required that in order to be a trial court judge in the business courts, not only did you have to be 35 years of age, a resident of the county in which you were going to serve for a certain amount of time, things like that, but you also had to serve for at least 10 years in either a complex business litigation practice, 10 years in a business transactional background, or as a judge with some kind of general jurisdiction within your trial bench. And so, or some combination of those 3 with 10 years of experience. And so by requiring that 10 years of experience, we were guaranteed, ideally, that all of these judges were going to have a business background. And that was the idea. Again, the legislature is giving litigants a forum where they're going to have a dedicated judiciary who's going to have experience with complex business disputes. And again, I think we've accomplished that. So I'm going to kick it back over to Mitch as we transition into a discussion of the jurisdiction of these business courts.
Okay, so as we mentioned at the beginning, this is a court of limited subject matter jurisdiction. And so what kind of cases can be brought within the subject matter jurisdiction of this court? There are really 5 what we've called buckets of jurisdiction, 5 different areas or ways to get into the court. And before we get into that, just so you all know, the statute itself only has 14 defined terms. Pretty much all of these terms, except for the last 2 here, relate to internal affairs issues of a company. But we're not going to get into all of them, but what we will get into are the definitions of publicly traded companies and qualified transactions. So the first bucket, these are going to be certain actions where the amount in controversy exceeds $5 million. So that is the first element that you got to tick off in order to get into the business court under this bucket. And that $5 million excludes your attorney's fees, court costs, penalties, all kind of things other than your actual damages. And also note that the court has concurrent jurisdiction with the district courts. And you'll see how this plays out later when we talk about removal and remand, because some cases that you could originally file in the Texas Business Court are going to probably get filed in regular district court, and then somebody will remove it to the business court. So $5 million, and then kind of a sub bucket is a derivative proceeding. So a derivative proceeding where there's $5 million in controversy, internal affairs issues regarding the governance or the governing documents of a company. We have claims arising under federal or state securities laws that are brought against certain entities or controlling persons, as well as auditors. I suspect that any case that gets filed in the business court that deals with federal securities will probably get removed to federal court. Remember, that's always going to be an option. Number 4 are this is a species of fiduciary litigation, and this one's a little bit different than the next one. It says an action by an organization or an owner, controlling person, managerial official of the organization brought against an owner and alleging acts or omissions in their capacity. So these will be fiduciary duty cases, again, exceeding $5 million. The next sub bucket is very similar, but it just doesn't say who brings the action. It just says any action alleging that an owner, controlling person, or managerial official breached a duty owed to an organization by reason of that person's status. So we're not sure yet how the courts are going to gloss on number 4 and 5 and how they're different. Number 6, these are alter ego claims. So someone's trying to get past the corporate veil or past the LLC veil and hold a member or a shareholder or an officer or director personally liable for a debt. This does not include actions where you have a controlling person or an owner or governing person who executes a guarantee. Finally, again, $5 million relating to then any action arising out of the business organization's code. So those are our bucket 1 jurisdictional elements. Bucket 2 is the exact same thing as bucket 1, except if you're a publicly traded company, you do not have to satisfy the amount in controversy requirement. So all of those 7 sub buckets that we just discussed, if the plaintiff is any party of the action is considered a publicly traded company, then you can get into the business court without satisfying the $5 million. What's interesting is the definition of publicly traded companies, which includes any entity that is majority owned or controlled by such an entity. So we may have a party in a lawsuit who maybe you peel back 5 or 6 layers of corporate ownership, and you find a publicly traded company that at the end of the day may control such an entity. We're not sure. There's no case law yet about how many layers of the onion you can peel back to get to that publicly traded company. But this will be an issue that you should keep on your radar screens when determining whether or not you have the ability to access the Texas Business Court. Bucket 3, these are certain actions in excess of $10 million. And again, like bucket 1, the amount in controversy requirement excludes your attorney's fees, exemplary damages, court costs, etc. And again, these actions can also be brought in district court. So business court has concurrent jurisdiction with the district courts over these types of actions. So again, I've got 10 million in controversy, and then one is an action arising out of a qualified transaction. We'll discuss that momentarily. 2, an action that arises out of a contract or commercial transaction in which the parties to the contract or transaction agreed in the contract, or a subsequent agreement that the business court has jurisdiction of the action, accepting insurance contracts, and we'll come back and talk about that too. And then 3, there are certain actions that arise out of the finance code. We won't talk about those, but let's start with qualified transaction. So the definition of the qualified transaction means any transaction other than an action involving a loan under which a party pays or receives or is obligated to pay or is entitled to receive consideration with an aggregate value of at least 10 million, or lends advance, borrows as receives, or is obligated to lend or advance, or is entitled to borrow money with an aggregate value of at least 10 million. So what is interesting about this is there are going to be situations where we're going to see contracts that by definition are qualified transactions because there will be consideration going either or both ways in excess of 10 million, but your damages under that contract may not be 10 million. So remember, you have a 10 million damages floor, but then you also have to satisfy the definition of qualified transaction. Vice versa, you may have a lawsuit where you have, a contract where a party's breached and you have in excess of 10 million in damages, but there's nothing in the contract that shows that there was consideration exceeding 10 million. That would not be a qualified transaction, even though your damages would exceed the $10 million threshold. So again, we're looking at both what are the damages, and 2, what is the value of the consideration under the contract. Let me go back real quick, because I said I wanted to talk about number 2 here. This is really interesting here. So independent from a qualified transaction is you have damages in excess of 10 million, and you have a contract where the parties agree that we can go to business court, or a subsequent agreement. So this is a situation where, let's say you have a contract that is not a qualified transaction, you have over $10 million in damages, and either before or after you file suit, you talk to the other party and they say, yeah, look, this is heading toward a lawsuit. We don't want to be in district court. Let's agree to go to the business court. That presumptively is allowed and can get you into the business court, even though you're not considered a qualified transaction. So one theme that you'll see here in this statute and the new law is that the legislature has really given litigators and litigants the ability to kind of forum shop a little bit and really try to figure out where you want to be depending on the nature of your dispute and where you're located. Okay, bucket 4, these are any lawsuit where you're seeking either injunctive relief or a declaratory judgment, and it involves a dispute that's based on a claim that would otherwise fall into the previous buckets that we discussed. So for example, and we'll talk about an opinion that recently came out where the court, I believe it was the third division, said that yes, if you want to get into business court on a declaratory judgment action, then you have to show, for example, that your amount in controversy is, or the value of the declaratory relief that you're seeking is going to be in excess of 5 million if you're trying to get under bucket 1, or in excess of 10 million under bucket 2 or 3, excuse me. And so we'll be able to make arguments kind of like you make in federal court when you're trying to satisfy the $75,000 threshold requirement, that yes, I'm seeking declaratory relief, but the amount and the value of that relief is going to be in excess of either the 10 or the $5 million, depending on the other bucket you're trying to get into. And this is the case that recently came out where the courts held just that, and we'll get into that a little bit later. I'll pass it to Jeremy now to talk about supplemental jurisdiction, which is a bit of a quagmire, but not too much. Lots of fun you can have as a litigator with respect to supplemental jurisdiction.
And before I dive in too far, I do want to touch on, Mitch keeps mentioning that we don't fully know how certain things are going to work yet, and there's a couple of recent opinions. Really, there's not a lot of precedent yet. And the reason for that, as I mentioned earlier, we have this new 15th Court of Appeals. And what that does is, the 15th Court is equal to the other 14 Court of Appeals. And so that means the 14 Court of Appeals that previously existed are technically persuasive authority to the new 15th Court. They're not binding authority. And so we don't expect that the business courts or the new 15th Court are going to diverge wildly from existing Texas law, but they could create their own circuit splits to the existing 14 courts. They could, we kind of see the business courts as freshly fallen snow to an extent. And we have the ability to make arguments that the new legislation and the new rules, that this can be interpreted in new ways, and that these rules and statutes can be applied in ways that maybe you wouldn't expect, because there's not binding authority out there interpreting this stuff. And that's what makes it so exciting. Mitch talked about at the beginning that this is exciting material for us, not just because we're huge nerds and we love this stuff, but because it hasn't been decided yet, and we get the opportunity to be the first ones to argue that kind of stuff. So anyway, on supplemental jurisdiction, a lot of you are probably familiar with federal supplemental jurisdiction. And so if you look at the language of the statute on the screen there, you're going to see some similarities, but you're going to immediately see some major differences. And so the first section talks about supplemental jurisdiction existing over claims that are both related to a case or controversy within the court's jurisdiction that also form part of the same case or controversy. And so that's really, it sounds similar, but it's really two separate elements, right? You can think of a breach of fiduciary duty claim, like an officer or director who maybe goes rogue. And so he performs two very separate actions. He goes rogue and he takes two actions on behalf of the company that are the same case or controversy, right? He has done two things that he was not authorized to do. Maybe he fired some employee and he signed some contract. It's the same case or controversy, but they don't necessarily form part of the same issue because they're two wholly unrelated actions. And so there may be a dispute as to whether the court has supplemental jurisdiction over both within the same case. But again, that's going to track similarly to some of the federal case law. It's really the second sentence where we diverge wildly. And that is that the business court can only exercise supplemental jurisdiction if the parties agree and if the judge agrees. So everybody has to be on the same page, and that's unique. The parties, so basically a defendant or even a plaintiff on a counterclaim has a trump card. They can simply disagree that a claim could be brought in business court and force the other side to have parallel litigation and say, no, you cannot bring your claim here. I do not agree, and force the other side to basically choose if they want to have multiple lawsuits or forego their claim for the time being. That's a powerful weapon, and that creates a lot of strategic decisions on both sides. So it's going to be interesting to see how parties use that to their advantage, especially with what Mitch just mentioned. If you're making a subsequent agreement that the parties are going to take their claims to business court, for example, you need to think ahead and say, okay, as part of that agreement, do I want to say, yeah, I'll agree to go to business court, but you need to agree that if I want to bring supplemental claims, you're going to agree in advance that I get to do that. And only on that condition will I agree to go to business court, just as a for instance.
Sure. And one of the problems that at least I foresee is that if you don't have an agreement with the other party, then the only other option then is to have two separate lawsuits. And then you'll have issues about res judicata or collateral estoppel. What if the cases in the business court are moving faster, which we'll talk about in a minute, they're supposed to, and that case gets resolved or comes to a judgment before the other case. I mean, it could be a real mess, and depending on what side of the V you're on, plaintiff or defendant, it could be a scary proposition having to really litigate in two separate forms. I suspect that the legislature may try to address this issue, but we'll keep monitoring, of course, the bills that are filed this legislative session. But again, a lot of pitfalls that you need to be aware of with respect to how this is going to potentially work.
Yep, absolutely. And so the legislature did not, we talked about the theme, right? The legislature gave litigants a lot of freedom, but they did put some guardrails on. And so we're going to talk about the prohibitions next. On subject matter jurisdiction, they gave us both some what we've deemed conditional prohibitions, as well as some total prohibitions on the kind of claims that can be brought into business courts. So the conditional prohibitions, these are claims that should not be brought in business court unless they can be brought under the supplemental jurisdiction that we just talked about. And so these are, there's a couple of buckets. The first is civil actions that are brought by or against governmental entities or foreclosure actions on real or personal property. So again, not brought in business court unless there is supplementally brought, which means the parties and the judge have agreed that those claims can be brought. Claims arising out of certain statutes and codes, and we've tried to give an explanation of what those are. So Chapter 15 there is non-compete agreements, the Deceptive Trade Practices Act, claims under the Estates Code, the Family Code, the Insurance Code. And you've seen on previous slides, there's a theme that actions under the Insurance Code and relating to insurance agreements have been carved out at various points. They are not typically allowed to be brought in the business courts unless in very specific situations. And also actions relating to certain liens and out of the trusts and property code. And then for whatever reason, claims arising out of the production and sale of farm products, consumer transactions, which is consistent with the carve out for the DTPA that we just saw. And then again, claims arising out of insurance policies. And then the total prohibitions, frankly, I think these make sense. So regardless of whether or not the court would have supplemental jurisdiction, you absolutely cannot bring medical malpractice claims, personal injury claims, or legal malpractice claims in the business court. That is not what the business court is for. And I think, again, everybody kind of understands and probably agrees with that. So I'm going to kick it back over to Mitch to talk about the removal aspect of the business court, which is, again, kind of a thorny quagmire all its own.
Right. So this procedure exists for cases that are initially filed in district court, and one or both of the parties, as you'll see, want to remove it to the business court. And this would be a good spot, I guess, to really explain at least what the legislative prerogatives were with respect to creating this court. One was, we know that especially in our big counties, Harris County, Dallas, Bexar, Travis, others, that there's a real big backlog in cases still from the COVID pandemic. It's just really hard to get cases moving and pushed to trial. Just a lot of backlog on the dockets. And so one idea was, okay, we have these really big sophisticated cases. Let's get them into another court system where they can move a little bit quicker. Not only that, but some of you are probably very familiar with Delaware Chancery Court, which again is very similar to the jurisdiction that the Texas legislature has now given to the Texas Business Court. And Texas wanted to have something like that. It wanted to have a specialized court for business disputes with again, fast-tracked judges who have really have a lot of experience in business transactions and in business disputes. And then also we were told that a big impetus for this legislation was to really attract businesses to Texas, to tell Texas, hey, look, or tell people, hey, come to Texas, you can do business here, and we're going to take care of you, and we're going to have this court system to help resolve any disputes that you may have, so you're not stuck in a 3, 4, 5 year lawsuit. So with that, we have the ability to remove cases from the district court. The first thing that's happened is we've already had cases that have been removed to the business court that were commenced before September 1st. Well, House Bill 19, which is the bill that ushered in the new court, specifically says that the act applies only to civil actions commenced on or after September the 1st. And so there have already been several cases and several opinions, and the different divisions, the judges are pretty legion in saying, yeah, look, if you have a case that's been sitting around for 2 years in the district court somewhere, you cannot remove it to the business court, even under agreement, because it only applies to any civil action commenced on or after September the 1st. And so a lot of the cases that have been filed have actually already been dismissed or remanded back to the district court because of this issue. So here's what the statute says, and it's really interesting. A party to an action filed in a district court or county court at law that is within the jurisdiction of the business court may remove the action to the business court. And if the business court does not have jurisdiction, then it has to remand. So one question we have is, well, the statute says any party. So even the party that commenced the action in the district court. And we think yes, based on the plain language of the statute, if you are, let's say, the plaintiff, and you initially filed a lawsuit in district court, and for whatever reason, you don't like the judge, who knows what, you say, man, you know what, I don't want to be here. You could considerably remove your own case from district court to the business court, whereas in the federal system, only the defendant can remove. Another question we have is, can a defendant remove an action from the district court to the business court based on a counterclaim that falls within the subject matter of the business court? So let's say you're the defendant, you're sued, and you have a counterclaim. And let's say that counterclaim arises out of a qualified transaction and your damages are in excess of $10 million. Can you remove it? Well, based on the plain language of the statute, maybe. It certainly seems like it. A party to an action. And so we'll see how the courts interpret this and whether they are going to be liberal with respect to their jurisdiction, or they're going to be really conservative and try to keep cases out. Another question, can an action be removed to business court from a county of proper venue that is not located within the boundaries of an operating division of the business court? Well, this is the Montgomery County example. If you have a case right now in Montgomery County, you cannot remove the case to the business court because there is currently not an operating business court division that governs Montgomery County. So be aware of that and make sure that if your lawsuit is in a district court somewhere and you want to remove it, you can only remove it if that county is currently within an operating extant business court division. Some more questions. What are the deadlines to remove? Well, anytime by agreement of the parties, or if no agreement, then not later than 30 days after the date the party requesting removal either discovered or reasonably should have discovered facts establishing the business court's jurisdiction. So we'll peel back that a little bit. One question that we have is, if this will work, there we go. Okay, so when you have an agreement, statute says a party may file an agreed notice of removal at any time during the pendency of the action. Party may file a notice of removal reflecting the agreement of all parties at any time during the pendency of the action. That's the concomitant Texas Rule of Civil Procedure. So we're asking questions like, okay, well, even during trial. Let's say you're in trial and for whatever reason the parties say, hey, we don't want to try this case here, even though we've been litigating it in the district court for 18 months. Based on the plain language of the statute, the answer seems to be yes, you could. And you could take your hypothetical even more extreme. What about even after trial? Again, very, very interesting statute and very interesting wording from the Texas legislature. Another question that we have is, okay, statute says that when you don't have an agreement, all parties or haven't agreed, then the notice of removal has to be filed within 30 days of either the discovery or you reasonably should have discovered facts establishing the business court's jurisdiction. There's another provision here that deals with pending temporary injunctions. But what's interesting about this is how it contrasts with federal court. So we all know that in federal court, a defendant has to remove within 30 days just simply after receiving a copy of the summons and the complaint. However, in business court, they're saying 30 days after you discover or reasonably should have discovered facts establishing the business court's jurisdiction. So is the receipt, for example, of just allegations in a petition, is that the discovery of facts? We have questions. What constitutes the discovery of a fact? What if your expert or the other side's expert produces their report, and for the first time you become aware that the other side is now seeking in excess of either $5 or $10 million? Is that the discovery of a fact? So we, again, have no idea how the courts are going to interpret this, but it certainly leaves a lot of room for lawyers to make a lot of good arguments for their clients, no matter what side of the argument you are on. Some other really simple questions. Where do you file the notice of removal? Will you file it both in the business court and in the district court? Another question, this is really important. Do you waive personal jurisdiction or other arguments if you file your notice of removal outside the due order of pleadings rule? So as we know, if you want to challenge, for example, venue, or you want to move the court to dismiss because the court does not have personal jurisdiction over your client, you have to do that before you answer. However, what the legislature has said is, I can remove a case, and that can be the first thing that I file in the district court, and it does not waive any defect in venue or constitute a special appearance or a general appearance. I can then go to the business court to have the business court decide my venue and personal jurisdiction issues. And so, again, the legislature has basically just said, look, we're going to provide a very small exception to the due order of pleadings rule with respect to getting into business court. Jeremy now is going to talk to you about some other interesting aspects of getting from the district court into the business court. This one is very interesting. Actually.
Yeah, so we talked about the theme of the legislature giving the litigants a lot of freedom, a lot of power. Well, it's not just the litigants. The legislature also gave the district court judiciary a little bit of power as well. As you see here, there is an option for the district courts to sua sponte, kick a case over to the business court in the appropriate circumstance. And so to cure or help cure some of that backlog Mitch was talking about, if a case qualifies, meaning if the business court would have subject matter jurisdiction over a case, the district court judge can, on its own power, go ahead and send a case to the business court. All the judge has to do is notify the parties, conduct a hearing, and this is pretty much the most subjective standard I can think of, decide that the transfer would facilitate the fair and efficient administration of justice. So basically, all the district court judge has to do is call the parties in for a status conference, say, I think that sending you to the business court is going to basically decide this case more efficiently, and off you go. We haven't seen that happen yet, not that I've found, but it doesn't mean it won't, and it doesn't mean it can't. So, pay attention. I think it's much more likely, obviously, that the parties petitioning the court or deciding to go to business court on their own is going to get you there, but this is always an option that the district court judges, if they're paying attention or if they really just don't like your case, could exercise at some point in the future here. Speaking of which, we're going to take a look next at the statistics of the cases that have been filed in the business court and some of the recent opinions that have come out. And so starting, I wanted to look at the statistics. This is, we had to finalize the slides. So this is as of Sunday. There have been 61 cases filed in the first, plus or minus 5 months here of the business courts operating. And you can see overwhelmingly the activity has been in the 11th division, which centers around the Houston, Harris County area. As a result of that, one thing that we haven't talked about yet is the freedom that the business courts have to assign cases to other business court judges to kind of bench swap, so to speak. And the 11th division has taken advantage of that. Already, we've seen a number of cases that have been filed in the 11th division, but that have been assigned to judges from the 1st, 3rd, 4th, and 8th division. So there are several cases already that are filed in the 11th, but Stacy Sharp, for example, or Bill Whitehill from the 1st division, they are currently presiding over those cases. And the legislature gave the business court the option, those judges, not only to preside over those cases, but to hold hearings and consider pretrial matters wherever they need to be, wherever those judges reside. So there may be cases filed in the 11th division that may have pretrial hearings held in other counties, but the jury trial, the ultimate trial, still has to be held in the county of proper venue where the case was filed. So the judges have some flexibility, and we expect that those judges are probably going to hold those matters, the pretrial matters, remotely for the convenience of the parties. But the ultimate jury trial still has to be held in the original county of proper venue. That's a right the parties don't waive.
And I would imagine that, for example, if a Dallas division judge gets assigned a case that was filed in the 11th division in Houston, then for trial, that judge would have to travel down to Houston.
And frankly, again, it's so early. None of those cases have gotten to trial yet. So obviously that hasn't been an issue. But the legislation and the corresponding rules are very clear that the trial itself has to occur in the county of original proper venue. As far as what these cases are, you see the breakdown on the screen. The orange is the removed cases. The red is the originally filed cases. And what the cases consist of, we're seeing a lot of energy companies involved in these. You might not be surprised by that. Those typically involve a lot of high dollar disputes. The $5 and $10 million thresholds are not always an issue. A fair number of real estate disputes where the underlying property at issue is a multi-million-dollar piece of land or building. And then, of course, a number of internal affairs type disputes where the amount in controversy is only $5 million and not $10 million. I want to talk about a few specific examples. So this is a case where, frankly, I pulled it because it's an original jurisdiction claim, and it's really, I think, what everybody kind of expected would be kind of a stereotypical business court claim. This was a case that arose out of a joint venture between companies to build a large data center. The plaintiff was originally the manager of the joint venture, and under the JV agreement was thus entitled to a specific profit share. Now, the plaintiff, again, this is according to the pleading, not taken aside. The plaintiff says that the project was projected to make $1 billion in earnings, and thus his profit share, or its profit share, would be approximately $250,000. The plaintiff goes on to allege that the defendants came up with some grounds to remove the plaintiff as manager, took over the manager role shortly before the project closed, thus taking unfairly the profit share. Obviously, $250,000 easily crosses the amount in controversy hurdle, and it is an internal affairs type of
$250 million.
$250 million. Thank you. It is an internal affairs type case, easily crossing that $5 million threshold. This is exactly the type of case that I think the legislature and commentators, everybody kind of expected would end up in business court. Now, another reason this case is interesting is because all of those entities you see in the caption there, those were all organized under Delaware law. The contracted issue chose Delaware law. The claims are brought under Delaware law, and yet the parties chose to bring the case in Texas. To Mitch's point earlier, this is exactly the reason the legislature explored bringing the Texas business courts to life, to give companies an option, to give businesses an option to bring this kind of litigation to Texas, and to give companies an option to establish their businesses in Texas. It's more lucrative now that you have this forum, and we're already seeing it, right? I mean, it might make more sense on paper to see this case brought in Delaware Chancery Court, and yet here it is in the new Texas Business Court. So it's exciting to kind of see that theory already come to life. The next case I wanted to talk about is the one Mitch already mentioned in passing, and this is the third division case that dealt with removal and kind of the framework of how removal actually works. I don't really need to get into the underlying merits of the case, but at a high level, this is another internal governance dispute. The actual facts related to the franchising of a string of coffee shops, a coffee business. But ultimately, the question that the court had to deal with was when a case is removed from district court on a declaratory judgment action or an injunction, how does the amount in controversy work? And how is the burden, the pleading burden and the burden of proof, how is that allocated? And so Mitch kind of showed you a quote earlier. We moved past it to save it for this part of the discussion. But you see the kind of numeral 1 and 2 there. The questions that were presented was whether the $5 million amount in controversy requirement limits the court's jurisdiction, and if so, how a dispute is resolved when a case is removed. And what the court held was that it only had jurisdiction if the amount in controversy was met, essentially meaning that even though it was an injunction or declaratory judgment action, the amount in controversy still applied, and that it was the movant that bears the initial burden on the amount in controversy. But it went further, and this is where I find this very interesting, and I think it actually really raises more questions than it answers, that the framework that's going to apply is the same that governs pleas to the jurisdiction. And so under a plea to the jurisdiction, it's really a shifting burden, a shifting framework, that there's going to be an initial pleading burden to essentially have kind of a prima facie case that then shifts to the other side. So there's a framework that the plaintiff essentially has to say, the court has jurisdiction, right? I have to plead sufficient facts to say the court has jurisdiction. The burden then shifts to overcome that. And that's now, it seems, what the business court is going to apply that same framework here for removal. Because again, if we think about removal in state district court, there's no amount in controversy pleading requirement. And so most plaintiffs aren't going to say, I have $5 million in controversy the same way that you will in an original action in business court. And that's what this opinion also recognized, is that normally the petition is going to be silent on this issue. And so it's not just a matter of who bears the burden, but how is the court going to determine that? And so what this opinion kind of goes on to hold is that initially the removing party is going to have to make some kind of prima facie showing that there is in fact an amount in controversy requirement that is met. And once that showing is checked off, the burden is then going to be shifting to the party seeking remand to show that either that amount in controversy is fraudulently pled or that is somehow lacking in order to actually obtain the remand back to district court. And so this is one of the few, if not the only opinion that's come out yet that really lays the groundwork for how the removal procedure is not only going to work, but how it's going to be challenged going forward. And now this is out of the third division. Again, because it's that freshly fallen snow. In theory, the other 4 divisions that are operating, they could come up with a different framework. They're not bound by this. The divisions are of equal precedential value. We don't expect that to be the case, but there could be divisional splits. But we expect this is probably going to be the framework moving forward. And so again, to me, it raises more questions than it answers, because for pleas to the jurisdiction anyway, there's more questions after this, right? For plea to the jurisdiction, that prima facie burden, the next question is, does the issue go to the merits of the case? And so for an internal governance issue, for example, we know there's a $5 million amount in controversy question. But the question behind that is, if it's an internal governance question, are you looking at the merits of the case? Is that your jurisdictional hook? If it goes to the merits of the case, the burden is lower because the court can't decide the merits of the case on the front end, right? That's got to be a question for the fact finder, for the jury at the end. But if it's a non-merits question, the court has to go further in determining whether it has subject matter jurisdiction on the front end of the case. And so I don't want to get into it here. I could go down a rabbit trail for sure. But there's a lot of questions that come later that I'm still very excited to see how the business courts are going to answer.
Well, and one hope that we have is that because we now have a brand new Court of Appeals, that Court of Appeals, as we sit here today, probably does not have a whole lot of work to do. And so as cases make their way up to the 15th, it's our hope that they come back down pretty quickly. And so hopefully over this next year, we'll start getting a lot of answers to these questions rather than having to wait maybe 4, 5, 6 years or longer for these issues to percolate and slowly make their way through the appellate system.
So I have a few more cases I can talk about. We've covered really the issues in those cases, at least tangentially today. So I'd be much happier to answer any questions. I don't see any in the chat yet. So what I'd like to do is I'll keep going, but if y'all have questions, go ahead and put those in the chat, and we'll stop and answer those as they arise. But I'll keep going until they come in. Is that fair? Does that make sense? Okay. So the next one, I did mention that we have a number of energy companies that have populated the early filed cases. So this is one that I put in here because it involves a public company. It's one of the first cases that we have that kind of tested the definition of a public company, because there's not actually a publicly traded company involved in the case, but you have to go up the chain. If you look at, again, the companies in the caption here, to get to one of the energy transfer companies listed there, one of the parent companies of a parent company is in fact a publicly traded company. And we don't have a written opinion yet challenging, or there's not a motion yet challenging whether or not that's a publicly traded company, and no written opinion yet from the court determining whether or not that qualifies, but we're keeping an eye on that one to see whether or not there's going to be a challenge to that definition. But this one's also included because this is one of those pre-September 1, 2024 cases that was removed. And we do, in fact, have a written opinion where the judge has said, no, you cannot remove a pre-September 1, 2024 case. But I thought the argument at least was interesting. The parties said that, Mitch talked about it earlier, that you can remove a case within 30 days of learning facts that make a case removable. And so, if this case has been hanging around for 2 years, you might be wondering, well, what on earth are the facts that you finally learned that would make the case removable? And what the parties argued were, well, 30 days ago, I learned that the business court exists. So they filed it 30 days after the business court opened. Clever, right? I mean, lawyers are going to lawyer, fair enough, but ultimately the judge was not buying that particular argument. But hey, look, points for creativity, right? And so here again, we have the order from the judge ultimately remanding the case. Although I say that I think we have 5 or 6 now that have been remanded in these various opinions, and most of them have already been appealed. And so the 15th Circuit is going to, or the 15th Court of Appeals is going to decide this issue pretty quick here. And then we'll see if that gets appealed even further to the Texas Supreme Court. But we're going to have finality on this issue sooner rather than later. And then, again, the same company, actually, Energy Transfer, one of the subsidiaries, actually raised the same issue, same argument in multiple divisions. And we were curious to see if there would be division splits. Not yet. Multiple divisions have now come down the same way on the same issue. They're all standing uniform. But again, they've been given the opportunity, at least, to diverge from one another and have so far declined to do so. But I did find it interesting that, at least in the 11th, both Judge Dorfman and Judge Adrogay were presented with different arguments on this removability issue. And they've clearly been communicating, because the parties made different arguments as to why the case should be removable. And Judge Dorfman issued his opinion first. And in his opinion, even though the parties made different arguments, he issued his opinion and specifically carved out the argument that the party in Judge Adrogay's case was making, even though nobody presented it to him. So clearly the judges have been communicating, and they're coordinating their approach to these arguments, because otherwise, I mean, he had no reason to carve out that argument proactively, other than to essentially reserve it to Judge Adrogay and make it very clear that he was not commenting on the other case. In the Lone Star case, the parties tried yet another attempt to remove a pre-2024 opinion. In this one, they tried to do it by agreement. Mitch talked about how by subsequent agreement, the parties can remove to business court. This one I thought had the most legs behind it. The parties argued that even though their case was pre-2024, by subsequent agreement, i.e. after September 1, 2024, the parties agreed to remove to business court. And because that agreement did not exist until after September 1st, 2024, the removal was timely. And even though they had distinguished their attempt to remove that way and made a unique and novel argument, the judge still did not buy that argument and stood with her fellow judges across the state, ultimately determining that the case was not removable. And so we do have a question that just came in. I'm going to put the QR code up there so y'all can get the CLE credit as we turn to the questions. And the first question is, can a district judge sua sponte order a pre-September 2024 case to be transferred or removed to the business court? That's a good question. My instinct on that would be no, because the legislation is what makes the determination. That's what all of the written opinions have hung their hat on, is that the legislature is the body that has limited the subject matter jurisdiction of the court. It's not the court deciding that it can't hear the case. It's that the legislature has not enabled the business court to hear those cases. And so for the same reason, they couldn't really create an exception just because the case was being transferred on different grounds.
Yeah, and I'd say that based on the reasoning of the opinions that have been issued by the business court judges who have addressed it, I agree with Jeremy that if their reasoning stands, then no, a district court judge could not sua sponte transfer such a case. That was pre-September of 2024. So.
Good question, though.
Yes.
Any other? And we're happy to sit around for a few more minutes if anyone else has any questions.
Indeed. And we will sit around, but we also just wanted to thank everybody for joining us
Absolutely.
today. Thanks for taking time out of your day to learn about the courts. To the extent that you have a pre-existing relationship with Gray Reed, reach out to your relationship lawyer here at the firm. We're happy to answer any more questions that you may have that may come up.
The mouse.
The mouse. Here you go. You may not have questions now, but you might think of something later. Please reach out to us. Let us know. We're happy to share our thoughts. Again, a lot of our thoughts are just arguments that have yet to be baked yet. Because again, all of this is really new, but it's really exciting too, and it'll give us an opportunity to really have some fun as litigators and be really strategic and play a fun chess match in any cases that end up in the business court. We do have another question. The question is, defendant removes the case, the business court rules one way or the other. The loser appeals to the 15th court. If the defendant is fine with or even wants a delay, doesn't that slow down the plaintiff who wants prompt justice?
So if I understand the question, essentially, can the defendant use removal and subsequent appeal to slow down the whole case? Honestly, if the defendant wants to delay and slow things down, staying in the district court is probably ultimately the slower proposition, and then appealing to whatever other appellate court is already in place. Now, waiting until the last minute to remove to business court is only going to work if they do so by agreement. Because if they don't have an agreement to remove, they only have 30 days from the discovery of facts supporting removal to do so.
Well, and I would say too that obviously we have rules such as is it Rule 11, Rule 13, other rules that require us to make colorable arguments and good faith arguments. But even assuming a defendant would have a good faith argument that the defendant thinks will probably lose, then the answer to the question is yeah. You go up to the business court denies or remands the case. You appeal that order remand up to the 15th Court of Appeals, and then at some point you're back in the district court. So I would say yes, that is a really good delay strategy if that's what you want your strategy to be. And again, subject to the ethical rules, you can certainly do that.
Yeah. Oh, I see now. You're saying potentially losing the removal.
You know you're going to lose.
Tax on.
You know you're going to
6
lose,
months to a year,
but you
to
can
18
tack
months.
on.
Oh, yeah.
A really long time. Well, very good. Again, thank you all very, very much. Hope you'll have a great rest of the week. And again, please reach out to us if you have any questions. Thank you.
Thanks, y'all.